Okay, well then let's start. Thanks everybody for joining this call. I'm Becky Laboon. I'm the chair of the ICE Public Member Committee. And before we start with the presentation for the day, I want to bring your attention to the public member resource page on the ICE website, which gives you more information about the Public Member Committee and also has some public member resources that are useful for public members as well as ICE member organizations. It's a work in progress and it's being reviewed and revised at the moment, but even in the condition that it's in, I think you'll find that it has some useful information. And to access the public member resource page, you go to the homepage, and across the top, you'll see a number of links, and you want to link on community. And once you get to community, over on the right-hand side of the page, you'll see public members. And if you click on that, you'll get to the resource page. And we hope you'll take a look at it. And if you have any comments or suggestions for additions, we'd be happy to hear that. And now I want to thank today's speakers and introduce them. We're going to first hear from Denise Roosendaal, whom you all know as the Executive Director of ICE, but she's also the liaison to the Professional Certification Coalition. And then she'll turn it over to Judish, who is an attorney at the Pillsbury Law Firm. And she is I think she did the nerve center for the PCC, and she'll bring everybody up to date on what on the current activities and what legislation and regulations the PCC is looking at. So Denise.
Great, thanks so much, Becky.
Well, I should say one other thing. The presentations are being recorded, but the recording will stop when we turn to questions and answers. So we don't record anybody who didn't want to be recorded in advance.
Right.
Okay, Denise, thanks.
Thanks so much, Becky. It's always a pleasure to be with you all and to talk about a very important initiative, the PCC, Professional Certification Coalition. I'm going to spend just a couple of minutes talking about the background, how we got here, and then turn it over to Joya, who's going to bring us up to speed on all of the things that we're tracking. So the PCC was created as a joint partnership between ICE and ASAE, the American Society for Association Executives, in 2018. This was created and pursued in response to legislation coming out of Louisiana, which at the time would have prohibited the use of the term certified by anyone who held any kind of credential other than a government issued credential. So the CAE, the Certified Association Executive, would have been prohibited from being used in the state of Louisiana. In our conversations with the sponsors, we realized there was a lot of confusion about terminology and really how private certification works in the marketplace. And so we also were fearful that this was a potential trend as other states were gearing up for their legislative seasons, and we wanted to get ahead of this and start having conversations with state and local officials around the importance of private certification and how it works, really. So we got in touch with a loosely formed coalition that had another focus in 2018 related to the Copyright Office, and we were able to form this group, this PCC coalition. We're now up to about 100 organizational members. We meet monthly to talk about strategy, to talk about what's happening, to gather intelligence on the ground from other organizations, and generally get an understanding of what's happening in the field that we are discussing. Now, I will say that outside of those meetings, we also are able to reach out to organizations that may be differently aligned than we are and have conversations, philosophical at times and other times practical, about what our views are on the role of certification and licensure in society and in the workplace. So with that, let me introduce Julia. Julia has been a part of the PCC since its inception. She is a critical component of the team. We have a steering committee, which is comprised of myself and the representative from ASAE, and Julia and her counterparts at Pillsbury, Winthrop, Shaw, Pittman Law Firm engage as well, Craig Saperstein and Jerry Jacobs. So at this point, let me turn it over to Julia to begin our conversation. Julia.
Thank you, Denise, and thank you, Becky. To the extent I'm the nerve center, I'm the frayed nerve center. So the PCC, I think it's important to emphasize, is a coalition of a wide range of certification organizations. Some of them, like in healthcare and finance and engineering fields, issue certifications that are developed independently by nonprofit groups, but that some or sometimes every state requires as a condition of licensure. Other certifications are what we refer to as wholly voluntary, like the CAE, and like ICE's certified certification professional, where they are signifiers to the public that the professional has achieved certain standards, but it's not required by law for that professional to hold their job, that they have that certification. And the PCC is neutral as to licensing requirements. What we really focus on are issues that affect the professional certification community as a whole, not a specific profession, and we're not pushing for more certifications to be requirements for licensure, and we're also not pushing for licensure requirements to be relaxed. So we really serve a helpful function for our organizational members, because our antennae are up with respect to issues that affect the certification community as a whole, broadly. Many certification organizations do have government relations teams or otherwise have partnerships with their industry or professional society, where they're keeping an eye out for, is there legislation that is affecting our profession specifically? But often these larger issues escape the radar of any specific certification organization or professional society. And I see that as a lot of the value that the PCC brings to certification organizations is filling that gap. I'll also say that our focus on what affects the professional certification community as a whole is closely tied to what is in the best interest of protecting public health, safety, and welfare. And as I go on in this presentation, I'm going to dive into some of the more specific kinds of state legislative initiatives we deal with. And many of them are legislative initiatives that affect licensure. And you may wonder, why is the PCC getting involved in so many issues affecting licensure when a big chunk of our membership are wholly voluntary certification organizations? And that's because we realize that even wholly voluntary certification organizations depend on the licensure system in terms of setting guardrails to protect the public, and don't want to be substitutes for licensing agencies. I'm particularly happy to be talking to a committee of public members, public representatives on certification boards, because that's the perspective you also bring to those boards, is of what is the public interest in this, not just the profession's own interest in it, advancing their careers. So let me dive in. I will start with, I can move these slides. There you go. I'm actually going to start not with the state legislation, which is the bulk of our involvement with legislation, but with a couple of federal initiatives that I just want to make sure that I have time to touch on. This has been not activity we engaged in at the inception of the PCC, but more recently, we've identified ways that the PCC can advocate for advancing nationwide federal level legislation that increases participation in certification and access to certifications. One of them is a pending bill, the mouthful of the Freedom to Invest in Tomorrow's Workforce Act. It is bipartisan and bicameral, so it's been introduced in the House and the Senate and has both Democrat and Republican sponsors. And essentially what it does is it takes 529 plans, these tax-favored savings plans, which traditionally have been limited to use for college, and it would expand it to cover the costs of obtaining and maintaining certifications. So whether for people who choose not to go to a traditional four-year college and pursue a certification as their path forward for their career, or whether it's for someone who college is years in the rearview mirror for them and they're mid-career and they're looking for a certification to really enhance their level of expertise and their career advancement. This would provide a way to use those funds for themselves or for family members to help fund access to certifications. The second piece of federal legislation has not yet been introduced, but it is very far along in the development stage, and the sponsors would be on the House side, Representative Derek Kilmer, Democrat, and on the Senate side, Senator Amy Klobuchar, also a Democrat. And this would provide grants to qualified certification programs and qualified training programs from the Department of Labor to pay up to $3,000 worth of costs for a qualifying individual to participate in the training program or the certification to rebuild their careers. The scope of who would qualify are those who really experienced job displacement during the pandemic and have exhausted their other forms of support, such as from unemployment. So long-term unemployed, the jobs that were there before the pandemic aren't necessarily the same jobs that are available after. And if you've been unemployed for a long time, the need to retrain and re-credential is significant in your ability to continue your career, as well as individuals who have served in the military and are rolling out of the military during this period, and their spouses. So we're very excited about this bill, both because of the funding it would give to open doors to these training and credentials for individuals who really need it, but also because it would create a process by which there would be a central federal database of what really are quality certification programs. And there's a number of definitions in the bill about how you could get that recognition from the Secretary of Labor to get a grant. Certainly certification organizations that issue credentials required for licensure would have a fast track to it. So would certification organizations that are accredited would have a fast track to it. But there are other ways that certification organizations can show that they are reputable credentials, that it's appropriate for the federal government to provide, grant money for these career rebuilding scholarships. So stay tuned on that. that we're very excited about. And let me move on to what's more of our bread and butter, which is the monitoring of state legislation and engaging in that state legislation. In our last fiscal year, see a map here, the majority of states have introduced bills that our monitoring has pinged as needing evaluation. We maintain throughout the year watch lists of these bills in which we analyze summarize the key provisions and analyze the implications and rank them in terms of priority or level of concern, low, medium, and high. For high priority bills and medium priority bills, we directly engage with the legislation sponsors and the legislators chairing the committees in which the legislation is initially reviewed. Our philosophy is, wherever possible, to suggest ways for the bill to be improved to address our concerns rather than seeking just to block its passage. But as you'll see, there are a few types of bills that we just outright oppose. Often the engagement is directly from the PCC, and we notify our members about legislation, sometimes give them templates if they want to reach out, if we think that we need to really activate grassroots engagement on it. We, with the guidance of the steering committee, have hired on-the-ground lobbyists in key states where there's been legislation that has been of significant concern. We engage with other, we call them stakeholder organizations, other groups that sometimes the legislation that's been introduced is based on model legislation that these groups have advanced, or they're otherwise involved, because our goal is not just specific to that legislation in Oklahoma or whatever the state is, but it is to educate legislators and educate the stakeholder groups about what the concerns are. That Louisiana bill that Denise mentioned that would have the title restriction on the title certified and also on the title registered, in 2018 and 2019, we continued to see bills like that, that we needed to engage with. The title restrictions really aren't much of an issue anymore in the bills we see, but other kinds of issues have arisen. That there are bills, and it's both satisfying and amusing in some ways, just some of these bills that come in that may, in essence, like the heart of them may be policy provisions that the PCC thinks are misguided or misdirected, but they include language that we have proposed and have been incorporated in amendments in other bills already to define what private certification is, to we call it our safe harbor provision that provides that legislation that may be placing restrictions on licensing agencies does not in any way require a private certification organization to change its eligibility standards or its disciplinary standards. So those sorts of safe harbor provisions we're seeing in a host of bills that we never touched. So there is this ripple effect of the PCC's engagement, which has had a lasting impact that's helpful for the professional certification community already. That does not mean that there's not still work for us to do, but it's nice not to be refighting those particular battles. So we've categorized the kinds of state legislation bills that we see. And I'll just talk you through the different categories. Two I've grouped together here are occupational licensing reform and the issue of government versus private certification. They are often paired in bills that we see. So a number of the more libertarian-leaning groups, such as the Institute for Justice, are very anti-regulation, anti-licensure, and they have a model bill in which they have articulated a hierarchy of regulatory measures from least restrictive to most restrictive. So least restrictive is open market competition, and people get on Yelp and see whether someone's good or not. And most restrictive is licensure. And in that hierarchy is private certification. Institute for Justice is a big fan of private certification. They would like to see it replace all licensure because it's private, and just leave it to the consumer to decide, should I go to this professional or not? Do they have certification from this organization or not? And it shouldn't be a requirement of licensure. As part of this hierarchy, part of their occupational licensing reform efforts, usually there is, the way the bills are structured, is that there needs to be some justification, either of the licensing agencies as a whole, or of a specific licensing regulation, whereby the burden is on the state for either a new regulation, so a sunrise review, or for renewal of an existing regulation, a sunset review, they call it, to justify that this regulation is the least restrictive regulation that would serve the state's legitimate interests under this hierarchy. The way these bills have been phrased often, though, is if the state can't justify licensure regulation under this hierarchy, the state should enact government certification. And that's something that the PCC opposes vehemently, and is often based on a misunderstanding or lack of understanding by the legislator about what that means. We don't want the state going out and becoming a competitor to private certification organizations, and the state usually doesn't have the subject matter expertise needed to set up a legitimate, validated certification organization to compete, that would compete with private certification. So we're often trying to improve that kind of language. The next two categories of bills are put in a variety of red because they're bills that we actually do outright oppose, or bills that include those provisions, we outright oppose those provisions. The Right to Earn a Living Act basically takes the hierarchy I just described and says that any person who is burdened by a licensure regulation, which is anyone, because licensure regulations charge fees, it's a burden, can challenge that licensure regulation, and they put the burden of proof on the state to prove by preponderance of the evidence that the licensure regulation is the least restrictive form according to that hierarchy. Almost any state would lose that because the hierarchies articulated in that way didn't exist when they enacted regulations. So there won't be evidence of whether insurance and bonding is a adequate and sufficient lesser form of regulation than a licensure law. And often it gives a plaintiff who challenges these laws the right to recover attorney's fees. So far, knock on wood, none of these have successfully passed, and we and other groups have opposed them. The same outcome with the Consumer Choice Acts, which keep coming back every year like a bad penny. These are basically end runs around any licensure regulation. They would allow, in any state that has a licensed profession, any person who is unlicensed for any reason, whether because they've had their license revoked or they don't meet the basic educational qualifications, or it doesn't matter, they would be able to practice that profession lawfully as long as they give notice to the consumer that they're unlicensed. Some of these bills are much flimsier than others, requiring only notice that it be posted in someone's lobby, not even any proof that the consumer knows about the notice that they're unlicensed. Others do require some sort of notice to the consumer that the consumer acknowledges in writing. But even so, it is a way to evade the licensure requirements that does not seem warranted. Most consumers don't understand what they would be foregoing if they hire someone who is unlicensed, or what the requirements are, what requirements that individual doesn't meet. Many times the consumer who is contracting for the services of a licensed professional is not in fact the end user. Think about having a civil engineer who someone hires to build a bridge. If they don't care whether it's a licensed civil engineer, they're not necessarily the one going across the bridge when it collapses. So we have opposed those bills as well. The next two kinds of bills are cousins of each other. And these really have come into more popularity, more frequency that we've been seeing them in the past couple of years. They have support across the political spectrum, and they require a very nuanced approach to addressing their provisions. What they are about is providing greater opportunity to people with criminal convictions. There's a real DEI, equity element to these bills, because people of color are disproportionately interacting with the criminal justice system, and often employers and licensing agencies, for example, have treated having a criminal record at all as a disqualifying black mark, that this is a sign that this person is a poor character and should be excluded from the profession. There are a host of bills in the employment context that trying to limit the way employers can consider criminal conviction history. And this is really sort of the next level of that, saying that licensing agencies should have only a limited basis for denying a license to someone who has a criminal conviction. So the ex-offender reentry legislation is sort of the umbrella term of which the clean slate legislation is one variety of it. And these the ex-offender reentry legislation tends to say that licensing agencies cannot consider an individual's criminal conviction history unless it is directly related to the duties and responsibilities of the licensed profession, or if a certain amount of time has passed by, or sometimes they parse it out based on whether it's a felony conviction versus a misdemeanor conviction. So our concerns there have been to make sure that the way the bills are phrased is not written so broadly or so poorly, depending on your perspective, that it would intrude on a private certification organization's decision about whether to grant a credential or discipline someone based on conduct, which also results in a criminal conviction. But also to make sure that licensing agencies aren't proceeding with blinders on. In our view, it's appropriate to have licensing agencies need to justify why they are denying an applicant a license based on criminal conviction history. But there's a difference between that and saying you can't even know about or consider this criminal conviction history. And this is especially important for trust professions, such as healthcare providers or financial advisors, where there can be criminal convictions that relate to fraud, for example, that don't relate directly to the duties and responsibilities of the position as phrased in the Practice Act, for example, but do greatly affect the safety, the health, or the welfare of the individual who's relying on that professional. Turning over financial information to a CPA who may have been convicted of fraud or sexual offenses that a healthcare provider may have engaged in it to try to protect the vulnerable public who, when they see that someone has a license, they see this as this is the state seal of approval. Clean slate legislation is a version of that, but what it does is it doesn't just say the licensing board can't consider this criminal conviction history. What it says is after a certain amount of time from someone's criminal conviction, unless they've had a new criminal conviction, that conviction is automatically erased, automatically sealed, expunged. They use different terms for it. The basis for that is also an equity concern. Already on the books for many kinds of criminal convictions is a process by which an individual who has had a clean record since they served their sentence can apply to have that conviction sealed. But that's requires a lawyer, it's expensive, people often don't know about it. And so what this does is it says, look, if we're willing to do this, let's make it automatic. And often they rely on data about recidivism and say, after a certain amount of time, there's much less of a risk that someone is going to reoffend. Let's just give them a clean slate. So we have concerns about that because it affects not just licensure, but also certification organizations. As you look at what are the behaviors that we expect of our certificants. Because often the exceptions to this clean slate process are crafted only to exclude crimes of violence or sexual crimes, and not to include crimes of fraud or other kinds of crimes that perhaps it's appropriate for a certification organization to say, we actually don't want someone like this. So one example that a PCC member, the American Board of Medical Specialties, shared with us, which I like to use because it really gets to the heart of some of the issues. If you have someone who is convicted of Medicaid fraud, that's a bad thing, right? They can be convicted, they can serve their time. But whether it should be a long-term disqualifier really depends on the facts underlying that conviction. If you have someone who commits Medicaid fraud because they perform medical procedures that cost $1,000 and they billed Medicaid $2,000 for it. That's a bad thing, but it does not affect patient safety. But you can also have someone who committed Medicaid fraud by performing unnecessary procedures on patients so they could bill Medicaid for those unnecessary procedures. That affects patient safety. And that is the kind of behavior that potentially should be a lifetime disqualifier from licensure. There's no way to just say, here's this criminal code provision on Medicaid fraud, and this one, you never get to look at it if there's been 5 years that have elapsed since that, to capture that nuance in it. So we've been working to try to get amendments to these bills made that do capture that nuance, that do capture the need for there to be exceptions for the kind of conduct that's relevant to licensing boards and relevant as well to certification organizations. There is one bill that is now law in Connecticut that in fact goes further than the licensing board and actually amends the Connecticut Human Rights Act to say that no membership organization or board for which a license is required for the profession can deny membership or recognition to an individual based on an erased criminal history record. And so we view that as intruding on the First Amendment rights of private organizations and have been engaging in Connecticut on that. All right, moving on to the final two categories. There's a big move, and it's not one that we necessarily oppose in concept, towards increased mobility between states and having what are sometimes called universal licensure, reciprocal licensure bills. These are different from interstate compacts in which licenses, the states come to an agreement on what is an equivalent license. And if you're licensed in, say, Maryland, and Maryland participates in an interstate compact with New Jersey, then you get to move freely between them. These bills, some of them are focused just on members of the military or military spouses because they often are moved around without a whole lot of control about that and trying to support their ability to work. But some of them apply to anyone. When they're reciprocal licensure, our main goal there is we support, having that increased mobility, but we want to make sure that it's the same scope of practice and equivalent standards. Because if the state makes a determination that in order to have a license in a profession, you have to have certain qualifications, the public is relying on that. And the fact that someone moved here from a place without those qualifications, if the state confers the license, they don't know, there's not an asterisk by them and said, well, they're licensed, but they don't have this. So, for example, there are 49 states that require funeral directors to have graduated from an accredited mortuary science program. There's one state that doesn't. So what do you do there? Why shouldn't that person still have to meet the requirements in order to get a license? Another concern we have is that many go beyond the reciprocity of licensure and instead say, well, if you're in a state that doesn't require a license, there's nothing for us to be reciprocal for. So we'll just substitute work experience, or we'll substitute if you have a professional certification, we'll give it to you. Those bills don't say if you have the same professional certification that is required for a license. So it could be one of these, buy them off the internet certifications that get someone into licensure. And work experience is not as a substitute for meeting substantive requirements. In our view, it could be someone who is fired for incompetence from every job. So, excuse me, we're trying to promote mobility, but to do it in a way that doesn't weaken the assurance to the public that licensure signifies. Lastly, in this past year, we have seen some bills and are monitoring, but have not yet engaged directly with them. Bills which, for the most part, are focused on healthcare professions that would aim to restrict discipline against professionals for engaging in speech outside of the direct patient healthcare provider context. So these tend to be responses to what we see on COVID. So people who get out on social media and promote, it may be a doctor, but they're promoting ivermectin as a treatment for COVID-19, or otherwise spreading information that is not accurate, that the vaccine's make you magnetic or something, but they're not doing it in the context of a patient-doctor relationship. And so these bills have largely been unsuccessful, but we're keeping an eye on them, and we're keeping an eye on whether there was one bill in Florida that would have directly affected certification organizations as well, what certification organizations could discipline professionals for, and whether the conduct undermines the trust in the profession, or people rely on it because they see Dr. So-and-so said this. It could have the potential for public harm. So that's just, it's a new category. We're just starting to track, but haven't yet engaged with, other than through the steering committee approved, and we have developed a statement of principles about those kinds of legislation. So that's a lot of me talking. Let me stop talking and let you all talk.
Julia, let me just jump in real quickly and say that I put the website address for the coalition in the chat. And on that website are some great resources that speak to much of what Julia has discussed today. There are position statements or white papers on a variety of different topics, and those are available to anyone to take a look at.
Yes, and it's also on this last final slide. And if you all want to distribute the slides to the committee afterward, you're more than welcome to.
Julia, before we turn off the recording, could you say a little bit about the lawsuit, the court decision in Ohio that affects remote proctoring? Because I think that's something that would affect.
The Ogletree decision. So first, I'll start by saying that it's important to understand that decision was issued on Fourth Amendment grounds because it was a public university that was involved. So the decision has no direct impact on a private certification organization that administers its exams itself, that is not under contract with a state or governmental entity. So with that caveat there, which it is important to note, since many of the articles about it don't really focus on that. The decision essentially was Cleveland State University did live remote proctoring exams. And at the last minute, I think it was less than 2 hours before someone who was supposed to take this exam the start time for it, he was notified, Mr. Ogletree, that he would have to do a webcam scan of his room, as part of the test security. You all can see where my cat is, but you can't see the mess that's in the rest of my study because I'm not taking the camera around. So Mr. Ogletree apparently had tax documents and settlement agreement drafts around and felt like he didn't have time to get everything in order, and that this requirement impinged on his privacy rights. And that because Cleveland State University was a public university, it was, he contended, an unreasonable search of his bedroom in his home, which is like one of the pinnacles of where you have a privacy interest. And he sued, and he was successful in a ruling that under those circumstances, without prior notice, or without much reasonable prior notice, with Cleveland State apparently being inconsistent in its requirements about whether a class remote exam would include a room scan or not, that it was an unreasonable search. It was a private remote proctoring company doing this, but it was doing it on behalf of this public university. So, although it doesn't have any direct legal application to private certification organizations, it certainly will, I think, have an impact on the environment of live remote proctoring. Many live remote proctoring companies provide services both in the private sector and for governmental clients. And so they're going to have to take this into account in terms of the kinds of the ways they conduct their live remote proctoring. Also, the opinion does contain some observations about what test takers feel is reasonable and fair in terms of invasion of privacy. And so even for wholly private certification organizations, I think there's some takeaways and food for thought and discussion about what is reasonable for us to expect of our test takers. Even if they're not taking it in a test center, should there be guidelines that we should have and expect? Should we be providing them resources to publicize that many public libraries have study rooms that with Wi-Fi that you may want to consider reserving if you don't want us doing it in your home, and having conversations with the remote proctoring companies about what they think is reasonable to do in these circumstances. And at a minimum, making sure that you provide ample advance notice to test takers about expectations for what they will need to show if they take that test remotely.
Thank you.
Did that answer your question?
Yes, thank you very much. Thanks to both of you. I guess I want to open the floor to questions